Good morning, all of you. Today, the topic is non-obstante clause. Introduction of non-obstante clause. There are different elements that are relied upon by legislature in constructing a statute, which can find while the interpreting them. Such aids or elements are used by law-making bodies in order to make their real intention clear to the public. Mainly, we can find two categories of element that aids construction of statute. The first category is internal aid to construction and the second is external aid to construction. Internal aid construction are all those aids that we can find inside the statute itself. Some example of internal aid construction are preamble, headings, explanation, and clauses. And external aids are that are not found inside the statute. Such aids are found. Such aids are not found in the statute. Example of external aid to construction are the committee or commission, official statement, dictionary, meanings, foreign decisions, historical backgrounds, etc. Non-obstante clause is one of the internal aid of construction. Background. Under very basic term, a non-obstante clause is affixed to section with an outlook to furnish enacted part that particular provision. In case conflict arise or overruling effect over the particular provision, either in that same act only or any other act mentioned in that non-obstante clause. This particular definition correspondent is saying that notwithstanding to the provision or the act or mentioned in non-obstante clause, the provision subsequent to it shall have complete operation, or the provision envisaged in the non-obstante clause shall not poise and hindering effect for functioning the particular provision in which the non-obstante clause occur. Definition of non-obstante clause. The word non-obstante clause stems from Latin and means notwithstanding or despite a law. When we see the word notwithstanding anything contained in this act, or notwithstanding anything contained in some particular act, or notwithstanding anything contained in some particular provision in the act, we can call such a clause as non-obstante clause. This is always inserted to beginning that provisions with the objective given the provision overriding effect over the statute or provision mentioned in non-obstante clause. It is essentially means that the spite of the provision or act mentioned in the non-obstante clause being in force, the provision that comes after that would fully enforce without being restricted by the provision or act mentioned in non-obstante clause. Such a clause is used to modify the act or provision it carry or restricted its application in certain circumstances. For example, क्लास में टीचर ने एक कमांड दी कि सभी बच्चे अटेंडेंस के लिए 8 बजे आएंगे, और कुछ समय बाद टीचर ने कमांड दी कि जब भी स्कूल में कोई भी ओकेजन या कोई फंक्शन होगा तो सभी बच्चे अटेंडेंस के लिए 7:30 बजे आएंगे। तो दोनों कमांड रेलिवेंट हैं, बट सेकंड कमांड फर्स्ट कमांड को यहाँ पे ओवरराइड कर रही है। This is called non-obstante clause. Object non-obstante clause is added to the provision in order to uphold its enforceability over another provision that is contradictory to it. This clause is used to clarify the intention of legislature in case where two provisions appears contradictory. How to interpret the non-obstante clause? It is the opposite of phrase subject to that we see commonly in statute. The word subject to are used, it means that the provision yield to another provision mentioned in the clause. Non-obstante clause used as in Indian Constitution. Article 5 to 11, the Indian Constitution deal with the right to citizenship. Article 5 entitled to the right to citizenship. Anyone born in or born to parents who born in India. Anyone staying in India for more than 5 years. Article 6 deals with the citizenship person who have migrated from Pakistan to India. Article begins with the word right to citizenship in certain persons who have migrated to India from Pakistan. Notwithstanding in the Article 5, before we see it enacting part, it is essentially means the provision in Article 6 prevail over the provision of Article 5. For those who have migrated from Pakistan to India, the same can see in Article 7 which states notwithstanding anything in Article 5 and 6. Article 34 Indian Constitution deals with the restriction of fundamental right where the marital law is imposed. It used the word notwithstanding anything in the foreign provision in this part indicate that the provision in Article 34 will prevail over the fundamental right granted by the preceding provisions in situation where the marital law has been imposed. Kalupur Commercial Cooperative versus State of Gujarat 2019. Mr. Seth submitted that although Section 48 of VAT Act has a non-obstante clause, yet it is well settled that the case of two conflicting provisions having non-obstante clause, the provision enacted later in point time will prevail. Such proposition S. Vinita versus the Deputy Commissioner on 15 December 2020. In present case, there are two acts, that is Act of 1992 or 1993 start with non-obstante clause. Section 34 of the Act 1993 starts with non-obstante clause. Likewise, Section 9A of the Act 1992, but incidentally the case Section 9A comes subsequently, come on 25 January 1994. There is subsequent legislation which will be overriding effect over the Act 1993, but cases might arise both of the enactment have non-obstante clause. In this case, the proper perspective would be one has see the subject and a dominant purpose for the special enactment was made. Third case is Kotak Mahindra Bank Limited versus Girnar Carburetor Private Limited 2023 Supreme Court. Fact of the case, the mission Viva Care advanced the various credit facility by appellant to secure the various credit facility plot number 16 or 14 situate to Sage area of Dhar were mortgage along with the certain movable fixed assets. Recovery of the proceeding under section 13 to SARFAESI Act and initiated by the bank account of default. Issue whether the recoveries under the MSMED Act would prevail over recoveries made recovery proceeding under the provision of SARFAESI Act. Supreme Court held that if the legislature confer the latter enactment with no obstante clause, it means legislature wanted to subsequent later enactment to prevail. Neither the district court nor metropolitan magistrate would have any jurisdiction to adjudicate or decide the dispute, even between the secured creditor or debtor, if any provision aggrieved by the step under section 13(4) order to pass under section 14, aggrieved person has approached the debt recovery of tribunal by way of appeal or application under section 17 Surface Act. It is observed that held so far as the recovery under Surface Act with respect to secure assessed would prevail over the recovery under the MSMED Act, recovery of the amount under award degree passed by the Facilitations Council. Rahmatullah Khan versus Assistant Engineer Ajmer, 28 May 2018. Land Council appearing for the respondent states that as per the instructions said decision not been challenged on Honorable Supreme Court. In view of above bearing in mind the fact admitted addition demand were raised sometimes month of May 2015 pursuant of audit objection or pertain to period from July 2019 to September 2011. Same were beyond the period of 2 years stipulated in the aforesaid extracted provision were thus barred by the limitation. And last case, Chief Information Commissioner versus High Court of Gujarat 2020 Supreme Court. This case is based on the conflict in RTI sections. Then the Supreme Court ruled that the information to certified copies on judicial side must be collected using the procedure provided by High Court rules, and the provision of RTI Act must not be invoked. Thank you for watching the video. Thank you so much.